I want you to think about a senior homeowner sitting at a kitchen table with a property tax bill in front of them. The number is not small. The average senior homeowner in this country paid about $4,271 in property taxes last year. That is not a minor household expense. For someone living on Social Security, a pension, a small retirement account, or a fixed income that no longer rises with the cost of living, that bill can feel like a second mortgage that never disappears. But the part most people miss is not the size of the bill. The part that matters is that for a very large number of senior homeowners, that bill was higher than it legally needed to be. Not because they were careless, not because they failed to negotiate, not because they did anything wrong, because there is a form that can reduce that bill, and most of the people who are legally entitled to use it have never been told it exists. That is the system I want you to understand. The ARP Foundation has confirmed that 9.3 million older adults qualify for a property tax reduction they are entitled to by law. Only about 8% of them have applied. That means the other 92% may be overpaying every year. Not because they lack the right, but because the right is hidden behind a process they were never taught to use. When I look at that, I do not see one mistake. I see a system. In systems, outcomes do not happen randomly. Outcomes come from incentives, rules, friction, and behavior. If a benefit is legal but not automatic, if it requires a form but the form is not clearly explained, if a deadline exists but the deadline is not mailed to the person who needs it, then the predictable result is that most people do not claim the benefit. That is exactly what is happening here. And there is another layer that makes this even more important. Some seniors do find the form. Some fill it out, some believe they have done everything correctly, and then a large number of them still get rejected. Not because they do not qualify, because there is one section of the application that many people complete incorrectly or leave unsupported. The county does not always send the application back and say, please fix this. The county can deny it, close it, and make the senior wait another full year. When you understand that, you stop thinking of this as paperwork. You start seeing it as risk management. That is the lens I want you to use. This is not a theory about taxes. This is not a clever trick. This is about a legal relief program that can reduce property taxes, freeze assessed values, or in some states, allow prior year claims when someone qualified but never knew to apply. The amounts vary by state. In some places, the savings may be a few $100s. In other places, the savings can be thousands. In New Jersey, the maximum savings under the Senior Freeze program can reach $6,500 a year. In Texas, homeowners age 65 and older can receive an additional $60,000 exemption, saving eligible seniors roughly $938 a year in school district taxes alone. In New York, legislation signed in 2026 allows localities to exempt up to 65% of a home's assessed value. In Illinois, a senior assessment freeze can lock the taxable assessed value of the home, so future increases in home values do not push the senior's tax burden higher in the same way. Those are not abstract numbers. They change cash flow. They change how long a person can afford to stay in the home they already own. They change whether a retiree has to cut food, medication, repairs, transportation, or help for a family member. And because property taxes repeat every year, the value is not only what you save once, it is what you stop overpaying year after year. That is why this matters. Let me show you the human version of the system. Take a woman named Carol. Carol is 68 years old. She spent 26 years as a public school teacher in Illinois. She bought her home outside Springfield in 2001 for $162,000. She did what responsible people are told to do. She worked, she paid her bills, she made the mortgage payments, she took care of her home, she paid her taxes. By 2024, that same home was assessed at $310,000. Her annual property tax bill was $7,400. Carol paid that bill every year for more than 2 decades. She did not complain. She did not ask for special treatment. She assumed the bill was the bill. That is what most people do. They receive an official number from a government office, and they assume it must be right. Then a neighbor mentioned the senior assessment freeze. Carol had never heard of it. She went to the county assessor's website and found out that she had been eligible since 2021. That means she had overpaid for 3 years, not because she was irresponsible, but because she did not know a legal form existed. This is the most important part of Carol's story. She was not an exception. She was the rule. There are millions of people like her. They are not financially reckless. They are not ignoring their obligations. They are doing what they were taught to do. They pay on time. They trust the system. And because they trust it too much, they miss the relief that the system technically offers but does not actively deliver. That is one of the great lessons about money and institutions. A right that requires action is very different from a right that happens automatically. If you qualify for a benefit but must discover it, understand it, file it, attach the correct documents, meet the correct deadline, and choose the correct form, then the real barrier is not the law. The real barrier is the process. The form is generally called the Senior Homestead Exemption. Some states call it the Senior Property Tax Exemption. Illinois calls it the Senior Citizens Homestead Exemption. The exact name changes from state to state and sometimes even from county to county. But the basic mechanism is similar. Your county calculates your property tax based on your home's assessed value. The exemption reduces the assessed value before the tax is calculated. If your home is assessed at $300,000 and your state exempts $50,000 for seniors, the tax is no longer calculated on the full $300,000, it is calculated on $250,000. That sounds simple, but the effect can be powerful because property tax bills are not one-time events. They come back every year. A one-year reduction helps. A permanent annual reduction changes the financial structure of retirement. Some states offer something even more powerful than a reduction. They offer what is often called a senior assessment freeze. This does not merely reduce the assessed value. It locks the taxable assessed value at the point when you file. If the market value of your home rises later, your neighbor's tax bill may rise with it, but yours may not rise in the same way because the taxable value is frozen under the program. That is a very different kind of relief. A reduction lowers the base. A freeze limits the growth of the base for a senior homeowner, especially in an area where property values have risen sharply. The freeze can matter more over time than the immediate reduction. The reason is compounding. People usually think compounding is only about investments, but costs compound too. Taxes compound when assessed values rise. Insurance compounds when replacement costs rise. Maintenance compounds when materials and labor rise. When a senior's income is fixed but the tax base keeps climbing, the home can become less affordable even if the mortgage is gone. That is why freezing the assessed value can be so valuable. It gives the homeowner a boundary. It creates predictability in a part of life where many retirees have very little flexibility. This is the kind of thing that sounds small when explained in one sentence but becomes very large over 10 years. A senior in New Jersey who receives $6,500 a year in maximum relief and stays in the home for a decade keeps $65,000 that would otherwise have gone to the tax bill. That is not coffee money. That is not a coupon. That is a meaningful part of retirement security. In Texas, the 65 and older exemption can save roughly $938 a year in school district taxes alone. Over a decade, that is nearly $10,000. And in many homes, $10,000 is the difference between a necessary repair being done and being delayed. It is the difference between replacing a furnace before winter and trying to stretch it one more year. In Illinois, the assessment freeze can become more valuable as home prices rise, because each year that the freeze holds, the difference between the frozen assessed value and the current assessed value can widen. This is why the form matters, and it is also why missing it matters. The program exists, but the program does not chase you. No one should assume that a county assessor will automatically apply it because the homeowner turns 65. That is not how most of these programs work. The property tax system is built around filings. The homeowner has to identify the exemption, confirm eligibility, submit the application, attach proof, and meet the deadline. If the homeowner does not do that, the bill can remain higher than it needs to be. The government can say the benefit was available. The homeowner can say, no one told me. Both can be true. That is the problem. In Illinois, the Senior Citizens Homestead Exemption has existed since 1994. That is more than 3 decades. Yet the existence of a program is not the same as the effective use of a program. If a senior homeowner never receives clear notice, never sees the form, and never has someone explain the distinction between one exemption and another, the legal right may as well be invisible. The ARP Foundation created an entire volunteer program because this gap is so large. Over the past 5 years, that program helped Americans recover nearly $10 million in property tax relief. That number tells you something. It tells you the money was there. It tells you the eligibility was there. It tells you the system did not automatically connect the people to the benefit. When a volunteer effort can recover nearly $10 million, the issue is not a few isolated mistakes. It is a structural gap between qualification and application. That is where people lose money quietly. Not through one dramatic event, through a bill that is too high every year, through a deadline missed every year, through a form never filed every year, through a document never attached every year, and because the amounts repeat, the loss compounds. This is why the deadlines matter so much. Florida closes the additional senior exemption on the 1st of March. New York City closes its senior exemption on the 15th of March. Texas closes on the 30th of April. Colorado runs as late as the 15th of July. Those dates are not always printed clearly on the tax bill. They are not always mailed to every senior who qualifies. They may sit on a county website that the homeowner has never visited. If the senior does not know to search, the window closes in silence. Then another year passes and the tax bill arrives again. This is one of the patterns I have observed over and over in financial systems. The most expensive mistakes often do not look like mistakes when they happen. They look like doing nothing. They look like not filing. They look like not checking. They look like assuming that if a benefit were available, someone would tell you. But systems do not work that way. A system is not compassionate or cruel. It follows rules. If the rule says file by the 1st of March, then the 2nd of March is too late. If the rule says attach proof of income, then an application without that proof may be denied. If the rule says the senior freeze is separate from the senior exemption, then filing one form may not secure the other benefit. That brings us to the trap that catches many people even after they discover the exemption. Most counties do not have one simple senior property tax form that captures every possible benefit. They often run multiple programs at the same time. There may be a senior homestead exemption. There may be a senior assessment freeze, there may be a circuit breaker credit, there may be a standard homestead exemption available to any homeowner regardless of age. Each program can have different rules, different forms, different deadlines, and different documentation requirements. To a person who has never dealt with this before, the names sound similar to the county office. They are different legal programs. That distinction matters. If a senior finds the wrong form, fills it out, and submits it, the county may process exactly what was submitted. It may not redirect the applicant to the better form. It may not call and explain that another program would have applied. It may simply deny the application and move on. The senior may receive a letter saying they did not qualify, but the real truth may be that they qualified for a different program. That is an expensive misunderstanding. That is why I would not approach this casually. If I were a senior homeowner, or if I were helping a parent or grandparent, I would not search one phrase, open the first document, and assume I found the right thing. I would look at the official county assessor's website. I would search specifically for senior homestead exemption, senior property tax exemption, senior assessment freeze, circuit breaker credit, and standard homestead exemption. I would compare the eligibility rules. I would check whether more than one application can be filed, and I would look for the deadline attached to each one. That is not overthinking it. That is protecting the claim. The second trap is even more direct. Many states that offer senior property tax relief also impose household income limits. In Illinois, the senior assessment freeze has a household income limit of $65,000 per year. In New York City, the limit is $58,399. In Florida, the additional senior exemption requires income below $36,000 per year. When income matters, proof of income matters. That is where many applications fail. If a senior submits the form but does not attach the required income proof, the application may be denied automatically, not paused, not gently corrected, not always returned with a note that says you forgot the document, denied, closed, one missing tax return, one missing Social Security award letter, one missing income statement, one more year of paying too much. This is the section that many people do not understand until it is too late. They think the form is the application, but the form plus the proof is the application. If the state has an income limit, the county needs evidence that the applicant is under that limit. A statement written on the form may not be enough. The supporting documents often decide whether the application survives review. That is why I would gather the documents before opening the application: proof of age, proof of ownership, proof that the property is the primary residence, proof of income where required, a driver's license, birth certificate, deed, mortgage statement, property tax bill, prior year tax return, Social Security award letter, pension statement, or other official income record may be needed depending on the county. The exact list differs by jurisdiction, and that is why the official county website is the place to start. Do not rely on a third-party site. Do not rely on a random article. Do not rely on the assumption that another county's rules are your county's rules. Property tax relief is local in execution. The state may create the authority, but the county often administers it. That means the correct answer is usually found through the assessor, collector, treasurer, or county tax office. This is also why retroactive filing matters. In some states, if you were eligible in prior years and never filed, you may be able to submit retroactive applications. Texas can allow claims for up to 2 prior tax years. Illinois can allow up to 3 prior tax years for certain senior freeze claims. That is exactly what mattered for Carol. She was eligible starting in 2021. She discovered the program in 2024. That gave her a 3-year window to attempt to recover prior overpayments. This is one of the most powerful parts of the story because it changes the emotional meaning of the form. It is not only about saving money next year, it may be about recovering money from years when the homeowner already qualified but did not know. If your parent, grandparent, neighbor, or spouse has owned a home for years, is over 65, and never filed, the first question should not be only, can we file this year? The question should also be, did they qualify in prior years? And does this county allow retroactive claims? That is where a person may discover that the savings are larger than expected. But again, the system will not do that analysis for them. You have to ask. This is one of the core principles I have learned from studying economic cycles, institutions, and household decisions. People often think financial safety comes from working hard and paying bills on time. That helps, but it is not enough. Financial safety also comes from knowing the rules that govern the system you are inside. If you own a home, property tax rules matter. If you are retired, income thresholds matter. If your home value has risen, assessment rules matter. If your county offers a freeze, the filing date matters. If retroactive relief exists, the look-back period matters. The person who understands the rules may keep thousands of dollars. The person who does not may pay the same bill every year and never know it could have been reduced. That is the difference between passive participation and active ownership. Now let me make the practical path clear. Do not start by asking whether the savings are worth it. Start by confirming whether you or the senior homeowner in your life is eligible. Most senior property tax programs require the homeowner to be at least 65 years old. They usually require the home to be the primary residence. They often require ownership of the property. Many impose income limits. Some programs require annual renewal, others may renew automatically after the first approved filing, but you should not assume that until you see the official rule. The correct first action is to go to the official county assessor or tax office website, search the county name with Senior Homestead Exemption Application 2026, then search the county name with Senior Assessment Freeze Application 2026. Then search the county name with Property Tax Exemption Deadline 2026. Then search for retroactive senior exemption or prior year senior exemption in that county. The objective is not to fill out the first form you see. The objective is to map the programs. A person who maps the programs makes a better decision. A person who grabs the first form risks filing the wrong one. After that, gather the documents before submitting proof of age, proof of ownership, proof of primary residence, proof of income. If the program requires it, if the application asks for household income, do not treat that as a casual line. Treat it as one of the most important parts of the file. Attach the documents. If the county website lists specific documents, follow that list. Then identify the deadline. Do not rely on memory. Write it down, put it on a calendar. Leave time for errors. If the deadline is the 1st of March, do not start on the 28th of February. The process may require an account, a signature, a notarized form, a mailed packet, or a trip to the county office. The risk is not only that you miss the date, the risk is that you find out too late that you needed one more document, then submit the application directly to the county office or through the official county portal. Keep proof of submission. If you mail it, use a method that gives you confirmation. If you submit online, save the confirmation page. If you hand deliver it, ask for a receipt or stamped copy. This may sound careful, but careful is exactly what the situation requires. A property tax bill is not a small recurring expense. It is a large annual obligation. When a legal exemption can reduce it, the application should be treated with the same seriousness as any other important financial document. And after filing, follow up. Do not assume silence means approval. Check the status. Ask when the exemption will appear. Ask whether it applies to the current bill or the next bill. Ask whether you must renew it next year. Ask whether the senior freeze and the senior homestead exemption are separate and whether both were filed. Ask whether prior years can be reviewed. The goal is not to be aggressive. The goal is to be complete. That is the difference between someone who is merely hoping the system works and someone who is managing the system. I also want you to understand the emotional trap here. Many seniors are embarrassed to ask for help. They may think a tax exemption means charity. It does not. This is not charity. This is a legal benefit written into the tax system because lawmakers recognize that rising property values can create hardship for older homeowners on fixed incomes. If a person qualifies, they are not taking something improper. They are claiming something the rules already provide. There is a big psychological difference between asking for a favor and enforcing a right. This is a right, and if 9.3 million older adults qualify but only 8% apply, the issue is not that people are undeserving. The issue is that the system is not reaching them. That is why this information matters most when it is shared with the people least likely to search for it themselves. A senior living alone may not know what to type into a search engine. A widow may not understand the difference between a standard homestead exemption and a senior freeze. A retired teacher like Carol may assume the county would have told her. A homeowner with a modest income may leave the income section incomplete because they think Social Security is already known to the government. But the county office may not know, or it may not be allowed to assume. Or the system may require specific proof. That is how people lose. Not because they are unqualified, because the process demands precision. If I were explaining this to a family, I would make it very concrete. Pull the latest property tax bill, find the assessed value, find the exemptions currently listed on the bill, look for words like homestead, senior, freeze, disabled, veteran, circuit breaker, or tax credit. If no senior exemption appears and the homeowner is 65 or older, investigate immediately. If a standard homestead exemption appears but no senior exemption appears, do not assume everything is covered. If a senior exemption appears but no freeze appears, check whether a freeze is available separately. If the homeowner has owned the property for several years and just discovered the program, ask about prior year claims. These are simple checks, but they can produce large results. And this is why I do not like the idea that finances are only about investments. Investing is important, but wealth is also protected through reducing unnecessary leakage. A person can work very hard to earn money, invest carefully, and still lose thousands through overlooked rules, avoidable taxes, unnecessary fees, and missed benefits. The best financial decisions are not always dramatic. Sometimes they are boring forms, sometimes they are deadlines, sometimes they are documents attached correctly, sometimes they are one call to the county assessor asking the question nobody thought to ask. That is the quiet work that often separates people who preserve wealth from people who slowly lose ground. I want to bring this back to the central idea. The average senior homeowner paid $4,271 in property taxes last year. A very large share of eligible older homeowners may be paying more than they legally need to pay. Only a small fraction have applied for the relief available to them. The most common failure is not necessarily ineligibility. It is ignorance of the form, confusion among similar programs, missed deadlines, missing proof of income, and failure to check retroactive rights. That means the solution is not complicated, but it does require action. Find the correct official county form, confirm the exact program, attach every document, meet the deadline, ask about the freeze, ask about retroactive claims, keep proof of submission, follow up until you know the result. If this applies to you, do not wait until the next bill arrives. If it applies to your parent, do not assume they know. If it applies to a neighbor, do not assume someone else has told them. The system will not necessarily warn them. The deadline will not necessarily announce itself. The county may not send a correction, and another year can close quietly. That is how money leaves a household, not loudly. Quietly, predictably, legally, and unnecessarily. Carol S.'s story could have ended with her continuing to pay the bill for the rest of her life. That is what happens to many people. But one neighbor mentioned the form, one conversation changed the outcome, one search revealed that she had been eligible for years. One set of applications opened the possibility of recovering prior overpayments. That is the lesson. Information is not useful because it sounds interesting. Information is useful when it changes behavior before the window closes. So if you are a senior homeowner, or if someone you care about is one, the question is not whether property taxes are high. You already know they are high. The question is whether the bill is higher than the law requires. That is the question to answer now, because in this kind of system, the person who waits for someone to explain it may keep paying. The person who searches, verifies, files, and follows up may keep the money in the household. That is the difference. And for many senior homeowners, that difference is not theoretical. It is the next tax bill.